Hi, welcome to Business Tips with Michael Tobian. Today we will be talking about what to include in a service contract. In our last discussion, we went over the concept of business agreements and contracts, and we discussed verbal and written agreements, the advantages to having a written agreement, and an introduction to this world of service contracts. Today, I'm going to be discussing things that I've learned that I've included in my service-based contracts. A lot of trial and error and some mistakes that I've made that I've refined in my contracts to something that's worked really well for me. I spent many years refining this. I started my event company, Utah Live Bands, in 2005. And over the last now 15, 16 years, I've just been refining it to where it's really something I'm really happy with. And it solves problems before they happen. I mostly deal with service contracts in my event entertainment business, Utah Live Bands that I just mentioned, and dancebands.com, which is a similar business, but it's more nationally based entertainment. And also, when I'm involved in business brokerage services, I deal with these service-based contracts. So please check out that first video when you get a chance. That gives an overview of contracts with service-based businesses. And we really chat about written agreements versus verbal agreements and advantages in both cases. So like I mentioned in that first video, I am in no way giving any legal or accounting advice to you at all. I'm simply sharing some things that have worked for me in my service businesses. I strongly suggest that you seek the advice of a qualified legal professional for specific questions about your business contracts. Every industry is different and every business is different. And even if you had a business in my industry, I wouldn't be giving legal counsel because I'm not an attorney. So let's talk about what are the essential elements of an agreement. Well, any agreement needs to have an offer and an acceptance. So one person offers some kind of service or product or something of value, and then the other person accepts it. And the offer contains some kind of terms, okay? Every agreement has to have an intention to create a legal relationship, and every agreement has to have consideration. So this term consideration. All right, I visited the website dictionary.law.com, and it defines consideration as a vital element in the law of contracts. Consideration is a benefit which must be bargained for between the parties and is an essential reason for a party entering into a contract. So, consideration can be a number of things. Deposits, retainers, money that's given for the contract. Earnest money is consideration for the contract, in some cases. Does consideration need to be money though? No. So don't let clients push you around with this concept if you have a service business. Let me give you an example. So consideration can be deposits, retainers, money that's exchanged, earnest money in some situations. But consideration doesn't have to be money. It can be a commitment. It can be something that's done that's of value that is provided by either of the parties in exchange for something else. All right, there are certain situations where an agreement might be totally invalid. So what are these situations where agreement is invalidated? One, if it's illegal or it entices somebody to commit a crime. So you could imagine if I were to hire somebody to rob a bank or something like that, that would be an invalid agreement. It's also invalid if it's entered into somebody who lacks the capacity to enter an agreement, for example, a minor. If it's entered in through some kind of misleading or deceptive conduct or undue influence. Another example where there will be something in the contract that's invalid is if two parties try to bind a third party. So, for example, if I and somebody else try to make an agreement that this third party will do something or will be involved in some way. Well, two parties cannot bind a third party. That third party has to sign and agree to the terms of an agreement if they're going to be held accountable to those terms. Okay, so let's talk about some advantages to having an agreement that is in writing as opposed to a verbal agreement. We actually talked about this extensively in the last video, so please check out that video called Verbal and Written Agreements. The main point here is that a written agreement provides much more clarity than a verbal agreement does. Even two parties that have a lot of trust in between them sometimes forget what they agreed to. They may not be trying to dupe or lie to the other person or they may not try to be disingenuous at all, but they just may have different memories or assumptions about what was agreed to. So usually it makes sense to put an agreement in writing if it's important. If in question, go ahead and put it in writing, and that's going to solve a lot of problems down the road. All right, making changes to an agreement. You might run into a situation where a change needs to happen into agreement. You might send it out to a client and they want to make changes, or they might ask you to make changes. Well, if you are not savvy with contracts and have a lot of experience, that now would be a great time to get the advice of an attorney about changes. I deal with so many contracts that I feel pretty confident with them. So usually I will just make these changes myself. Or if I'm working with somebody that makes changes, I'll make the determination myself whether those changes are appropriate, oftentimes. If it's something really important or something I'm not familiar with, I'll get an attorney involved. If you do find yourself in a situation where you have decided to make your own changes to the contract, some advice I got once from an attorney was to not use a lot of fancy language, like you're an attorney. In legal contracts, sometimes the way you word something means something totally different than if you might word it a different way, and you might have no clue as to what these different words mean, will versus shall, and different things like that. So the advice that was given to me is when you're adjusting your contracts, don't use a lot of fancy language. Very clearly and in plain language, just state what the new agreement is or the addendum or whatever it might be. Another thing I do when I'm trying to adjust contracts or when I'm making new contracts is I try to think of unfavorable scenarios that may result from the contract, and I try to clarify those in advance. I do this because I've had bad experiences in the past with it, and I have a good feel for what scenarios might occur in the contracts that I end up engaging in, just from past experience. So for example, I have an entertainment agency, and sometimes we sign exclusive acts to our agency, and when we do that, all their bookings need to go through us. Well, I've had problems in the past with different scenarios where the acts have wanted to book around us because of certain situations that may have been justified. So I've learned from those scenarios, and I'm very clear to define what that act is and what exactly the terms of that exclusivity are, so that both parties are very clear as to what situations are okay to not be exclusive and what situations must be exclusive through our agency. Another thing that I've had to do recently with the COVID-19 pandemic, with these events that I do, is I've had to clarify what happens to this retainer in situations of an act of God or a pandemic like COVID-19. What do we do with that retainer? This is an unforeseen circumstance. Everybody's dealing with it. Usually our retainers are non-refundable, but there have been situations where we've, worked with clients. And so I've had to add things to my contract for these type of situations that we've never dealt with before. You may want to get an attorney involved in drafting and amending your contracts. This is highly recommended in almost every situation, especially if you don't have a lot of experience with contracts and you don't feel comfortable writing and amending and doing things to your own contracts. Some things that have been helpful for me when I hire an attorney is I will explain extensively the situation to the attorney. Sometimes if you don't explain what you do or what you want in that contract extensively enough, they may make assumptions and they might not write a bad contract. So explain to him or her what is important and exactly what you do so they can be thorough when they're making that contract. Another thing that I do when I hire an attorney is I'm very aware of the hours that he or she is billing. I've sometimes noticed that attorneys start the clock anytime there's any communication. They send a text, they bill you. They email you, they bill you. They get on any phone call, they bill you. That's fine because they are doing work. But sometimes people don't realize an attorney is billing them hours when they really are. So what I usually do is I save up my questions and I fire them all in one email or something like that. The attorney responds and it's efficient. And sometimes I call if I need to, but there have been attorneys that will just love to chat and they ask how you're doing and then they go on forever to explain things. And the whole time the dollars are billing. So you should be efficient with your attorney's time so that you can get the most out of your attorney as possible. I'm also really careful about working with attorneys that don't try to just bill hours for the sake of billing hours. I don't personally like that. I've had attorneys that review contracts and they spend a lot of time with it, and the changes they made were pretty incidental that I thought. And I thought, man, you just spent a lot of time and didn't really add any value. Perhaps you're just billing hours because you want to bill hours. Maybe you got a slow day. Well, that comes into a question with ethics, which we have another video, several videos on ethics. But be careful about attorneys who are just billing hours. You do want your attorney's advice, but just be kind of monitoring, and it's not offensive to ask an attorney about the hours they're billing and how that works. They can explain that to you. All right, other things you might find in contracts. Sometimes contracts will have a severability clause that deals with, if certain items in the contract are found unenforceable or unlawful, perhaps the rest of the contract is still in force. There's oftentimes language that determines where the dispute may occur. Usually it's the state that one of the parties is in, or the county or something like that. Contracts oftentimes have timelines for when the service should be provided or needs to be completed by. Contracts almost always have price and terms in them. Sometimes they deal with cancellations of the agreements or the service. In the event somebody wants to cancel, is there a retainer that's retained, or is there a deposit that's kept? Is that non-refundable? When is the final balance due? Sometimes people are net 30. Sometimes people need to be paid before the service is provided. And a contract, like we talked about before, outlines the party names, the information, the date by which the agreement is made, which that date sometimes is important in certain agreements. And in some situations, the date might have to do with the resolution of a dispute. There are lots of specific terms for your service or your industry that you'll want to include in your contract. So you may want to talk to other people in your industry, see what they put in their contracts, look at other contracts that you see. Sometimes you can get ideas from free contract templates online. But most importantly, like I said before a couple times, speak with an attorney and get specific advice and instruction with your situation. Thanks so much for joining us today. Please check out the other video I did on contracts called Introduction to Verbal and Written Agreements. And please subscribe if you like more information and business tips going forward. We also do have a Facebook and Instagram page, so tell your friends. I hope the information is helpful, and thanks so much for joining us.